Hi, I'm Catriona Hatton and I'm the Managing Partner of Baker Bott's Brussels office. I've been practicing here in Brussels for over 20 years in EU and international competition law, and with the team here we handle a lot of transactions for companies, coordinating together with our other offices around the world global merger filing requirements and getting the approvals needed to get your deal done. So I wanted to share with you in this session just some of the tips around organising that whole process, making sure that you don't miss out on some issue which could delay closing, and just sharing with you some of our experience. First of all, I'll just take a very brief look at merger control around the world, and it will be very brief because there are more than 100 countries now with merger control regimes. And then we'll talk about some of the key questions you need to go through to make sure you do the analysis correctly, and as I said, you don't miss any critical issue. We'll then talk a little bit about timing considerations, assessment of risk, filing, not filing in certain jurisdictions. I'll talk very briefly about joint ventures and minority acquisitions, which can raise particular issues, and then we'll just look quickly at some practical considerations around getting the data that you need and preparation of the merger filings themselves. So starting first with the multi-jurisdictional merger control, we now have at least, well over 100 countries worldwide that have merger control, and that number is growing every year. So unfortunately, although there's a lot of work around trying to harmonise these regimes across the world so that you don't get much variety in the approach to the process and indeed the substantive analysis. That effort in the ICN and other fora is working to some extent, but you still get just very large variations, which again presents its own challenges in trying to get a transaction done within a reasonable time frame. And that's obviously something your outside counsel can help with. But all of this comes down to a message that says you really have to carry out this merger filings assessment very early on in the life of a transaction and well before signing, because in some cases you're going to have to file a transaction within a week of signing, and it will often take a lot more than a week to prepare the filing. In other cases, you'll have to plan for potentially a very long waiting period before you can get a merger approval. And of course, it's important to identify any substantive issues that could affect the transaction. There are some deals where once you assess these substantive issues, you may decide not to proceed because you know that it's potentially could be blocked, or that the remedy you have to give will go too far and could deprive the deal of its real value. So that assessment really has to take place early on. Now, this is really just a very quick sort of snapshot of some developments, because with more than 100 countries worldwide, you can imagine that a lot happens in a year. But in terms of big jurisdictions, India introduced new merger control rules in 2011. They have a very long period to review transactions, up to 210 days, and this was certainly worrying when the merger control rules were introduced first in India. In practice, the Indian authority has been dealing fairly quickly with non-complex mergers, which is good, but it is hard to guarantee the timing when the actual time frame is so long. Ukraine, what I've mentioned in relation to Ukraine is that the jurisdictional thresholds are very broad, so they catch transactions which may have no local nexus to the Ukraine. If one party has €1 million of revenues in the Ukraine, or assets of that value, and the other party is not present at all in the Ukraine, provided it meets certain worldwide thresholds, a merger filing has to be submitted. And what we see in the Ukraine is increased enforcement by the authority against companies who have failed to fulfill their merger filing obligations. And then Brazil last year amended their merger control regime. One of the big changes there is that you now have to wait for a Brazilian approval before you close your deal. Prior to this, you could file in Brazil and then close your transaction prior to approval. And then finally, the United Arab Emirates have introduced competition law, including merger control, although they have yet to issue the merger control thresholds, but it's something that we need to be aware of in handling international transactions, that is another new jurisdiction where you may have to file. So looking at some sort of practical considerations, there are lots of things to take into account, and this is a very important process because if you miss something, you can find that it really impacts the timing and the outcome of your deal. So, I mean, first of all, what data do you need for the merger filing assessment? You can certainly run your first analysis of what merger filings might be triggered by just taking the target company data by country. There are important sort of assessments to be made there on what is local turnover or revenues in a particular jurisdiction. So, for example, is it on the basis of revenues generated from products that are shipped to a country? Is it on the basis of revenues generated from invoices to customers issued in a country? Generally, it'll be on an invoice basis. Sometimes it's shipped to, and that's something that also needs to be taken into account. Then to do a more thorough assessment, at least at a second stage, you will often need more data, for example, market shares, assets, seller, buyer. So that's quite an exercise, and again, needs to be taken on quite early in pre-transaction. Then a question that we often hear is, why would I need to file if the target's not present? Well, as I mentioned in relation to the Ukraine, some jurisdictions do catch deals where only, for example, the buyer is present. In Spain, they catch deals where potentially only the target is present, because if you acquire a certain level of market share, that triggers a merger filing. So it is possible that even if only one of the parties of the transaction is present in a country, you still have to do a merger filing. What if a deal triggers merger filings in 3 or more EU member states? Do you need to file all of these at national level? Are there other options? Well, there is an option to go to the European Commission and get sort of what we call one-stop shop review, so that you avoid multiple national filings. That is often the way that parties will choose to go, although it may have timing implications. That process can sometimes take longer than actually proceeding with the national filings. So these things need to be, again, assessed based on timing to assess the sort of best route to go. Is there a filing deadline? I mentioned some countries have very tight filing deadlines. Cyprus, for example, requires a filing to be submitted within 1 week of signing a transaction, and Ireland within 1 month. And a lot of the time these are serious deadlines, so it is often not possible just to get an extension, and sometimes some countries will impose fines for missing the filing deadline. So that's very important to identify, again, very early on in the deal. What countries do I have to file in, and what countries have filing deadlines? And then, is the filing mandatory or is it voluntary? Again, sometimes you hear from clients, well, why would we need to submit the filing if it's voluntary? Most regimes around the world require filings to be made if you meet the thresholds, but there are others like Singapore and the UK and Australia that have a voluntary filing regime. And that really means that you've got to carry out some substantive assessment in order to decide, should I file the deal? And these authorities will generally not want to review a deal unless there is a potential antitrust issue in that country. So that requires some substantive assessment. It may also require contact with the authority to discuss with them whether or not you need to file. If you don't do that assessment and decide not to file, the risk is that you sign up your deal, it becomes public, and the authority contacts you, and then you have to deal with it on the back foot. Some agencies in the world can review transactions that are below the merger thresholds. Certainly in Europe, we're quite used to making this assessment that says, do we trigger a merger filing based on the thresholds? And if we don't, we're safe, and our transaction is not going to be reviewed. But that is not universally the case. For example, the US, Canada, China, Brazil and Ireland are just some of those examples. And so you need to also consider, if your transaction raises antitrust issues in a country that can take jurisdiction below thresholds, what's the risk that you may have to deal with an investigation? Is approval required prior to clearance? So most countries, yes, is the answer, but there are some exceptions where they allow you to file and close. Mexico is one. Since most countries require you to suspend closing pending approval, you may find yourself in a situation where you've handled everything quite well, everything's gone smoothly, and you've got your approvals, but there's one jurisdiction where an approval is still pending. And that can potentially, obviously put the deal timeline out quite considerably sometimes, depending on the time period for review in that country. And so then the question sometimes comes, well, can we close anyway? Often the answer is no, but there are some countries that will allow you to close globally, but carve out the local assets so that local closing doesn't take place until that country has approved the transaction. That can be quite complex on the business side and from a commercial law point of view, but sometimes worth considering where you really have one outlying jurisdiction and a lot of pressure to get a transaction closed. Are there any post-merger filing requirements? Everybody's always very focused on getting the merger filings done, getting their approvals and closing, and sometimes forgets that after closing, you may well have to deal still with merger filings. Argentina is an example of a country where after you close your deal, if you trigger filing, you can file then. And I'm currently dealing with a transaction where 1 year after closing, it's still been reviewed by the Argentinian authority. So something that needs to be kept in mind, that when you close, it may not all be over. Looking now at timing, I mean, there are some potentially very long formal review periods. Brazil and India are two. Some jurisdictions where it may even be open-ended. And you also have to factor in other things. So, for example, pre-filing contacts with the authorities. In the EU, you will not submit a filing without having spoken to the Commission, submitted at least one draft, if not multiple drafts, got their comments. And if there are some serious antitrust concerns, you may take several months of pre-filing contacts and exchanges with the Commission before you will trigger the formal review period. So that's something that you need to bear in mind. You need to factor in timing to complete procedural obligations. So you may be doing very well on preparing your filing, doing the analysis, getting comfortable that you're not going to have an issue, and then be ready to file but find that you don't have a notarized POA, or it's not correctly apostilled, or the accompanying documents still need to be translated into Turkish or whatever the local language. And that all needs to be taken care of again early on, so that that is not a delaying factor. And then risk assessment. I mean, at the end of the day, with so many regimes worldwide, and frankly, not all of them with very sensible jurisdictional thresholds, you get to a place where you can go through your list of countries and say, okay, we have 8 filings or 15 filings, but in some of these, they're based on the seller and buyer having very little in the country concerned, maybe one party only being present and clearly no sort of local nexus or no local issue. And then you've really got to look at, do we want to do this filing? And you've got to factor in a lot of things there in terms of what's the risk of enforcement, what's the experience of the authority, and weigh the risks in a way of filing versus the risks of not filing. In countries where authorities are maybe understaffed and don't have a lot of experience, if there's really no impact in the country concerned, then you will need to think about, can I put this filing in and risk that it's 6 months down the line and I still don't have an approval and I'm delaying my transaction. So a lot of factors to be weighed in that risk assessment. I'm going to speak really very briefly about joint ventures and minority acquisitions because this could take a whole other session. It can be a quite complex assessment as to when a joint venture or a minority acquisition can trigger a merger filing. On the EU level, a joint venture will only trigger an EU merger filing if it's a so-called full function joint venture, which means that it's an autonomous economic entity. It's not totally reliant on the parents for all the inputs or access to the market. So that's one assessment that needs to be made. Well, actually, one more point with regard to the EU is that the European Union Merger Control Regulation catches joint ventures which may have absolutely no activities in the EU. It's because of the way the thresholds are structured. For example, a joint venture between 2 large companies who meet the EU revenues threshold, who set up a joint venture to operate only in North Africa, can be called by EU merger control, and the Commission does enforce its merger control rules against those joint ventures. So that's another aspect of it that you will need to take into account. Then minority acquisitions, again, European merger control catches minority acquisitions, but only if they confer control on the minority shareholder. And that means, for example, that they would have some potentially strategic veto rights. So some rights that will allow them to control strategic commercial decisions of the joint venture, for example, a veto over the budget or business plan or appointment of senior management. So that again requires an assessment of whether the minority shareholding actually gives that level of influence. And then there are many other national regimes within the EU and in fact globally that catch minority acquisitions even where there's no control. So for example, Germany, the UK and Austria. And then again, globally, there are also a number of regimes like Israel, Korea and Taiwan, which have jurisdiction over minority acquisitions. So some practical considerations when it comes down to pulling these filings together. You may have 5, 7, 9 filings across the world. On data gathering, I think it's always good to ask your outside counsel to make sure they give you one consolidated information request, because a lot of these jurisdictions will require some, at least, of the same information. And some of the general analysis of the markets is going to be the same whether you're filing in Korea or the EU, at least at a sort of top level, and then you'll need to go into a local analysis. So there's always quite a lot of common information, and what you don't want is that you're getting 10 lots of questionnaires from different counsel around the world without sort of having consolidated them into one request. What's, I think, very useful in our experience is to have a key sort of business person, one business person, that can be the liaison with the outside counsel or with the in-house team who's responsible for pulling the data, for giving the input on the market analysis, and that can bring in the relevant people that you need to kind of make this the assessment of the market and the competitive assessment. I think that's always very useful, and it's also very efficient, and things tend to move quickly when there's somebody in charge within the business of doing that. It's important to identify reliable third-party studies on the markets that you're analysing, because generally the agencies will look at those. They may request that the parties buy them, and you'll need to be able to make a comment that you consider them good, or that you consider them to be slightly out or even way off because of certain factors. Because if you're saying your market share is 15%, but the third party study is saying it's 30, there is some explaining to be done. So that is something that you do need to also look at and take into account. And then you need to really be careful in drafting both the internal and external documents. The internal documents, which are prepared, for example, for a board to assess the potential transaction, will often be requested to be submitted with the filings. The US authorities require quite an extensive so-called 4C documents that need to be submitted, so internal documents as well as external communications. And so that needs to be sort of carefully handled, because there are ways of saying things from a business perspective that may raise antitrust red flags. And there are often ways, once the antitrust lawyer is involved, that you can sort of reconsider what the appropriate language is to say what you want to say, but without raising unnecessarily an issue. And then finally, you really need to be very careful that the story you're telling is coherent and consistent across jurisdictions. It is not anymore at the stage where you file in one jurisdiction and the other jurisdictions takes no heed of what you're doing elsewhere in the world. Most cases, the agencies will ask you, where else are you filing? They will often be in contact with each other, exchange non-confidential information. They'll ask for waivers to exchange confidential information. So your story really needs to be consistent. So that wraps up our presentation for today. If you have any questions, you're very welcome to call or send us an email. We hope this was helpful in sort of sharing some of our experience over the years in how to pull this process together to make sure that you don't miss any sort of key considerations in the process. And thank you for listening.